And finally, we have Geoff Walsh, who served as a legal services attorney for over 25 years before joining the staff of the National Consumer Law Center. He's presently a staff attorney with NCLC's Boston office. His practice is focused upon housing and bankruptcy issues, and he's a co-author of 2 recent studies by the National Consumer Law Center on issues affecting the current foreclosure crisis: Foreclosing a Dream, a study of state foreclosure laws, and state and local foreclosure mediation programs. Can they save homes?
Thank you very much. Again, my name is Geoff Walsh. I'm a staff attorney with the National Consumer Law Center in Boston. And NCLC is a nonprofit organization that has been providing backup services to legal services programs around the country that provide free legal assistance to low-income consumers, and particularly in the areas of foreclosure and bankruptcy. We do trainings for legal services attorneys around the country, and do various publications about issues related to foreclosure. We've been publishing these books for about 30 years, and nobody's really reading them very much. But lately, the sales have been doing pretty well. And we've been involved very much in training mediators and pro bono attorneys who are doing a lot of the representation of homeowners in foreclosures around the country. We've been following the status of foreclosure mediation programs since 2008, when the first ones appeared in various parts of the country. And I have to say that initially we were a little skeptical. I mean, the idea that great things are going to happen just by people meeting doesn't always occur. It may sound nice, but unless there are some standards that are going to be applied in these sessions, we've had some concerns that we would just see a lot of modifications that might be redefaulting again. And I have to say that we've really changed our view given what's happened in the foreclosure mediation programs, particularly over the last year and a half. There have been a lot of programs in different states that have set out creative ways for the mediations to be managed. They set requirements for servicers to produce certain documents and to complete certain analyses of whether, for example, a foreclosure is going to be better for investors than a loan modification, and in many cases the loan modification may be better for investors in that particular loan. And there are spreadsheets, there are calculations that can be reviewed so folks can figure that out when they're sitting down. And we think that those kinds of programs serve a great benefit for homeowners and for investors in mortgage-backed securities that really are kind of left out of the picture here, where it's a situation where it's the servicers that are really, the loan servicers that are really calling the shot, or calling the shots in a foreclosure. Since roughly mid-2008, at least 20 states have developed some type of foreclosure mediation or conference program. And these are programs that require a lender or a servicer to meet in some type of setting with a borrower or the borrower's representative and review loss mitigation and loan modification options before a foreclosure sale will be allowed. To date, 6 states have passed this type of statute. 3 state Supreme Courts with judicial foreclosures have ordered mediations in all residential foreclosure cases. And then in 6 or 7 other states, individual county courts, particularly county courts in large metropolitan areas, have required foreclosure mediation in all cases in their jurisdiction. And that includes cities like Cleveland, Toledo, Columbus, Philadelphia, Cook County, Chicago, and Milwaukee all have their own individual foreclosure mediation programs. And the data that's coming out about how these programs are performing is really very encouraging, both in terms of the outcomes and in terms of the numbers of homeowners who are participating in them. The program in Connecticut has been in effect since mid-2008, and they've completed over 14,000 mediations in foreclosure cases there. Over half of those cases have resulted in homeowners coming out with agreements that allow them to stay in the property. and over 40% have resulted in loan modifications. And one of the more recent developments that I think is extremely important is the situation in the state of New York, where they've recently made foreclosure conferences mandatory in all judicial foreclosures there. They've conducted almost 90,000 foreclosure conferences in the state of New York just in the first 10 or 11 months of 2010. And what's remarkable is that 80% of the homeowners involved in these cases are showing up for the conferences. I've been representing homeowners in foreclosures for 25 or 30 years, and it's very typical in judicial foreclosure states even for only 10 or 15% of defendants who were named in these cases to file something in court or appear at all. But what you're seeing in New York is that over 80% of the borrowers are showing up for these conferences. And in the majority of cases, they're coming out with resolutions that are allowing them to stay on the property. There's a foreclosure mediation program in the city of Philadelphia that has been in operation also since mid-2008. And again, they're getting 60 to 70% of eligible borrowers to show up for conferences. And what this is really showing is that despite what some media analysis has been portraying, that there are somehow all these borrowers out there who are strategically defaulting or hiding out or wanting to game the system, there really are a lot of homeowners facing foreclosure who very much want to talk about settlements, particularly ones that involve them paying money. And you don't go to these conferences if you don't want to either make an agreement to pay whatever you can afford to pay and get that cash flow starting back to the servicer, or make some arrangement where you'll be moving out of the property and terminating that particular relationship. So these mediations aren't set up for people who have any interest at all in gaming the system. They really do help to deal with problems related to loan servicers. And again, we're talking primarily about loan servicers. Over 85% of the foreclosures, 85% of the mortgages that are being foreclosed in the country today are being serviced by entities that have contracts with the Treasury Department, with the HAMP program, to modify all eligible loans under that program. And the servicers typically don't own these loans. They didn't originate the loans. The loans are owned by trusts. These are passive entities that have a legal existence, and that's about it. They don't participate in the foreclosure process. Servicers that are under contract with these trusts are basically the ones that are engaged in pursuing the foreclosures. The servicers have incentives to get the foreclosures completed quickly. They get paid a lot of fees that they get to take off the top for a lot of activities related to foreclosures. And they don't like to keep the foreclosures going for a long time because they're advancing certain costs. Their incentives in this process are very different from the investors, who may be towns in Norway or retired school teachers in New Jersey and have fractional interests in multi-billion-dollar mortgage-backed securities. So the foreclosure mediations are a way of bringing servicers under some type of review, under some type of scrutiny, in a situation where their incentives to foreclose are often very different, certainly from the homeowner and even from the investors themselves. There are studies that have been done in terms of housing counselors and how they interact with some of these larger servicers. And the servicers, again, are typically subsidiaries or affiliates of large depository institutions. There are 5 or 6 that are responsible for most of the home loans and the foreclosures in the United States. But studies that have been done, for example, by the California Reinvestment Coalition of Servicers found that typically servicers have to send the same modification application documents 5 times to these servicers before there's any acknowledgement that they've been received. There are rules for the federal HAMP modification program that require that temporary or trial modifications be made permanent after 3 months. servicers are reporting typically that homeowners are going into temporary plans at least 14 months before getting any final decision about whether they qualify for a final modification. And the Congressional Oversight Panel's review has indicated that probably in about 70% of the cases, although there's a requirement for the servicer to give a formal written decision about a loan modification review, borrowers are not getting those decisions in writing in about 70% of the cases as to why they're being denied a loan modification. And another very common problem, a very serious problem, it has been servicers who are foreclosing either while borrowers are being reviewed for a loan modification or are complying completely and 100% in good faith with obligations under a temporary payment plan. There have been about 1.5 million trial modifications approved so far under the HAMP program, but only about 500,000 were actually finalized. About 500,000 of those were just denied for reasons that were often undocumented in the majority of cases. The other 500,000 are just sitting out there and nobody really knows what's happening with them. And it's a tragedy that there are 1 million homeowners who made the effort to get involved in this program, submitted all these documentations about starting all these modifications and wanted to tag, but were simply thrown out because of the haphazard way that the program is being administered. And states certainly have authority to require any servicer that's foreclosing in their jurisdiction to follow guidelines, for example, those that apply to the HAMP program. Again, servicers don't choose, or rather borrowers don't choose who their servicers are going to be. It's an industry that, in any other area where you saw this type of misconduct, it would be regulated strictly. If you had an organization like Amtrak and it started putting people on trains and sending them to the wrong city, people would get mad about that and it would be changed. If you had an electric utility company that just started arbitrarily shutting people's lights off and sending them bills for 10 times more than they owed, there'd be a public outcry about that. There does need to be regulation of mortgage loan servicers as well, just the same that we would want rules to apply to a railroad or a utility. And I think this is an important area that needs to be addressed. There are objective, industry-recognized standards for what servicers are supposed to be doing, and a good foreclosure mediation program, like the one that's proposed in the bill that you have, simply requires that servicers who, for example, have signed on to these federal modification programs follow recognized sound industry standards in deciding whether to modify a loan or to foreclose. So with that, I'll go see